we have an extraordinarily strong, not just a strong argument, I think an uncontested argument. We're the armed attorneys. Today we're talking about the United States versus Matthew Hoover. This is our auto key card case. Y'all asked for it in the comments in previous videos. We've got it. Please stick around. We're going to be talking about what's going on with the Hoover case, what he sold, what he's charged with, and not only the Second Amendment grounds for his challenge, but also the First Amendment grounds. But before we get started, show your support for the Second Amendment by hitting the like button. And please take time to check out our sponsor for today. That's Legal Heat. Although we have a state of the world today, which is that constitutional carry is the law of the land in more than half the states, it doesn't mean that having a license is a bad idea. In fact, I will just tell you personally, as a self-defense lawyer, I think it's an incredibly good idea. When I stand up there in front of a jury arguing your case because you've had to act in self-defense, there's some kind of magic to saying that you have a handgun license. I don't know what it is. I don't know why juries love it so much, but they do. Legal Heat is a great provider of all sorts of firearm education, but that license in your state, if you're eligible, can be a very powerful thing.
Now, starting off, we're talking about the Hoover case. Now, this isn't just a dam or a vacuum. It's, some would say, a political prisoner in the state of Florida, related to, auto sear key cards. Now, these aren't finished out, milled out, or completed auto sears. These things are just a little bit different because they are templates, or maybe they would be treated like a template, but essentially it's just information on a piece of metal when you really look at these things. But give us a kind of a quick overview of what this case is about him.
Yeah, well, Matthew Hoover, along with another, is charged with the transfer of multiple machine guns, because essentially the federal government is alleging that each one of these auto key cards, right? We're talking about the size of about a business card. Y'all, I'm sure, remember this when he initially got raided and charged. Size of a business card, just that print of what you would have to cut out on this little piece of metal, drop it into your AR. You've got fully automatic weapon, right?
Because laws are so ridiculous and so out of control, if I were to cut on these lines, I would become a felon.
But he's not selling the auto sear. He's selling something very, very different. And yet the government alleges that that key card with the print on it is in and of itself a machine gun. So he is charged with unlawful transfer, and he is also charged with the conspiracy to violate the NFA and to, commit this unlawful manufacture, possession, transfer.
As you would cut this out, this piece right here you would cut out would fit in the slot right here.
Yeah, and I would say some analogs to this would be, the Def CAD cases or the defense distributed cases. Really what we're talking about is information, and as opposed to maybe just a digital file with the information, it's printed on a medium. In this case, it's a piece of metal. Now, I think there are some big implications here with not just Second Amendment rights, but maybe First Amendment rights like we've seen in those cases. What do you see coming out of that, Em?
Our analog here is that it's like defense distributed. The government's saying not at all, right? The government's argument is this is just a straight NFA violation. But I agree with Richard. To me, we have two issues here. We've got First Amendment issues and then, of course, Second Amendment issues. But the First Amendment issues are compelling. This is speech, right? If I'm his lawyers, that's part of the argument I'm making, of course. Now, in a post-New York State pistol and rifle world, we have even better Second Amendment arguments to make. But, we look at defense distributed, we look at anarchist cookbook, we look at the past cases that should tell us and tell the government, you can't do, this isn't inciting violence. Right. There is no exception to Matthew Hoover's ability to exercise his First Amendment rights in this way. This is a First Amendment issue. What someone else does with his speech that he has enacted, on this auto key card is not Matthew Hoover's crime. That's step one, I think. Great First Amendment argument. And then we have, I think, two separate and distinct Second Amendment arguments, both good, both exciting. So let's dig in.
So I would say the first one there is, we talk about the underlying the National Firearms Act and the taxing authority that the federal government has with regard to certain items: short-barreled rifles, shotguns, machine guns, AOWs, destructive devices. Now, what makes this a little bit, Harry, is and how it's intermingled with First Amendment issues is we don't really see taxing authority on other fundamental constitutional rights. You don't have to pay a tax in order to express yourself. Like Emily said, the First Amendment, and maybe it's not speech that we necessarily agree with, but the First Amendment doesn't exist to talk about the weather. I mean, it's to express controversial ideas in many circumstances. And so taxing speech, maybe it falls under that category. Or we look at some of our other fundamental rights. We know that a poll tax is not constitutional. And so maybe it falls in there. But going to the underlying elements of the National Firearms Act in the post-Bruen world, I would say is the second key component there. And what are your thoughts on that?
Well, we have to look towards, is there history and tradition for this kind of regulation, right? What is our historical analog from the time the Second Amendment was enacted that tells us that this kind of regulation is okay? I mean, that's our test, right? I can't say that enough. This is our new test because it's exciting. We are watching it implemented. And this is, in fact, what Matthew Hoover's lawyers have filed a motion to dismiss. And they are arguing this New York State pistol and rifle versus Bruen standard. If I'm the government here, I'm hard pressed to come up with some sort of analogy as to why this kind of regulation is lawful based on the history and tradition. Can you think of anything at all?
No, and this is going to be the work of scholars. And we had a great discussion with Mark Smith over at Four Boxes Diner. You have to go check out his YouTube channel. He's a Second Amendment scholar, constitutional scholar, and has some great discussions. And that is the work of the kind of intellectual wing of the Second Amendment community. We have our work cut out for us at this point, and we see a lot of attempts to rewrite history about what was going on at the time of the founding of the country. But when we really sift through this stuff, it does not appear that there is a historic analog to regulating these things. And even, I don't even think we need the Bruen standard necessarily to get there, because we have some other precedent.
Yeah, so this is what's really interesting. So imagine, if you will, that we are still in the pre-New York State pistol and rifle versus Bruen world. We don't have this beautiful new standard. I think there were still really good grounds to challenge this, because when we look back at United States versus Miller, which is, the first time we have gun laws reaching the United States Supreme Court. It used to be one of our only firearms cases, but we have Miller, and this is just a very brief rundown of Miller. Miller challenged his arrest for possession of a short barrel shotgun. He was arrested, charged under the NFA, challenged this. Miller, unfortunately, did not get a chance to make very good arguments because his lawyer did not show up to argue in front of the Supreme Court. And in fact, I think Miller was actually shot to death before the opinion was rendered in a weird twist of fate. But what Miller did is uphold the National Firearms Act as constitutional. Perhaps if he had had an attorney making arguments, it could have gone the other way. You never know. That's a really sad sort of footnote of history. But in the Miller opinion, we actually have, as part of the court's reasoning, this idea that a short barrel shotgun is not a military weapon. And the suggestion that had Miller been in possession of a military weapon, and that be the basis of his NFA challenge, that they might have thought something differently. And we've actually got the quote here. We'll flash up and read to you. Certainly it is not within judicial notice this weapon is any part of the ordinary military equipment or that its use could contribute to the common defense. Well, of course, we have an extraordinarily strong, not just a strong argument, I think an uncontested argument that machine guns are military equipment.
Ordinary military equipment.
So I think that, to put Bruen aside, would be a fascinating argument to make, just on the basis of what the court said in Miller to challenge the constitutionality of the NFA. But of course, add to that New York State pistol and rifle versus Bruen, and my hope goes out to Matthew Hoover that he's got a really, really good basis for his motion to dismiss here.
Yes, and this is kind of the uncomfortable part of challenges to the National Firearms Act and how they kind of pop up. He is under criminal indictment in the whole full force of the United States government against him. And you better believe his life is very, very disruptive. And we see those things in the comments. Hey, this is unconstitutional, will not comply. And we understand all those sentiments, and believe us, we are with you when it comes to that. But this is where the rubber meets the road, and it's his bacon on the line. And so send your well wishes to Mr. Hoover, because this is one of those things where maybe this leads to an untangling of the NFA, that we have some of these infringements rolled back and our Second Amendment rights restored. But we hope you enjoyed this discussion. If you did, consider subscribing, hitting that like button, and help us fight the anti-2A algorithm by sharing this video.
And please question and comment below. Until next time, we're the Armed Attorneys.